All right, everybody. On behalf of Trident Title, Performance Title, and Synergy Title, we are going to welcome Mr. Paul Krasker to another episode or edition, whatever you want to call it, of Better Call Paul. Today, we're going to talk about co-ops, and we're really going to cover two documents. So the purchase of co-op addendum and the FAQs for co-ops. These are two things that are in the Florida Interactive Forum. So if you're using .loop or DocuSign or whatever, they're in there. I'll tell you, I even had some trouble finding them. You have to type in the full word cooperative, otherwise you don't always find them. So if you're not seeing them, or if you're in one of these transactions and you don't know where to find them, that is what you look for. I'm going to share my screen over and let Paul take it away. So Paul, tell us what we need to know about co-ops.
Yeah, so one of the interesting things is there are no FAR forms on co-ops. This is a FAR form. I don't know why the committee refuses to address the issue, but these are just realtor forms. Okay, a general introduction. Co-ops are different than condominiums. They are used in multi-story buildings just as co-ops are, but the difference is when you're buying into a co-op, you actually do not buy real estate. You buy a percentage ownership in the company that owns the whole building, and you get a proprietary lease to lease the space that your unit represents. So if it's an 8-building co-op, you end up owning 1/8 of the building, assuming each unit is the same size, and you pay 1/8 of the expense, and you get a lease from the building to yourself or whatever entity you own in for the specific unit that you're purchasing. Now, when you go to get title insurance, there are some lenders who will not lend to a co-op. Most do. And you do get title insurance, but you only get a leasehold title policy. It's just as protective as an owner's title policy, but it's an acknowledgement of your real property interest is technically as a lease from the building. I can run down the particular paragraphs and ask if anybody has any question. Paragraph A is just clarifying what I just said, that this is not a fee simple interest in real property. It is an equitable interest in a company and a leasehold interest. There are a bunch of disclosure things because it's very difficult to know because these proprietary leases are not put of record. They ask the seller to make certain representations. For example, whether there's a blanket mortgage on the overall building, whether there's a mortgage on the specific unit. If there is a mortgage on the overall building for improvements or something else, does seller's interest equate than less than their percentage of the building? For example, if there's 10 units and $1 million mortgage, then everybody has $100,000 of liability, assuming all the units are equal size. And if that's the case, then you really don't have any equity in your property if you're trying to sell your property for, $50,000. You have to subtract your net interest in that mortgage to come up with what your equitable interest is in the property. Again, paragraph C talks about whether or not there's a ground lease. Some of these co-ops, the owner of the land built the building and then sold it as a co-op, but there was a ground lease that the owner signed, a 99-year lease from the owner to the co-op. And at some point in the future, and if you bought one in the 60s, then that 99-year lease is coming up in 40 years. In 40 years, you won't own your co-op anymore, it will go back to the original owner's family. Seller's warranty, representing that they own the shares. Obviously, it's very difficult for you to determine who owns those shares, and you can get confirmation for the association. But we're also asking for a rep and warranty here in D. In addition, closing documents and closing fees are E and F. Closing documents are, as I mentioned. I will say this, the sellers are traditionally represented by realtors, and the realtors traditionally try to push those closings on to whoever their favorite title company is, Trident Title and Performance Title and Synergy Title, of course. But this is probably one circumstance where if you have a listing in a co-op, you're not going to be able to steer it to us if the association has an attorney of record who prepares all the closing documents. So you can send it to Trident to do the leasing title policy, the leasehold title policy, and the closing statement, but the closing documents are usually prepared by the association attorney and not the seller's attorney. And the seller usually pays for those association attorneys to draft the assignment and assumption document. Let's see, jumping to the second page, G is just talking that there's a leasehold title policy. H is the cooperative association. There are association approval rights as there are with condominiums, and there's always a right of first refusal on these things. If you've ever heard of the stories with President Nixon wanted to move from California to New York after his resignation, and there were 3 cooperative buildings in a row in New York who rejected his application mostly for reasons that they didn't want the publicity and they didn't want the crowds in the building. So the right of first refusal is a legitimate right that the association has. Buyer pays the application fees, parking, boat slips, just like a condominium, and seller pays all fees prior to closing. And here in paragraph 6, there's a separate paragraph that talks about pending or anticipated litigation with regard to the property or common elements. And then there's a disclosure of the fees. Let's see, because each person owns a percentage of the building itself, here there is an obligation if there's damage before closing that the seller pay whatever that damage is, or the buyer gets to walk. And then paragraph 9 is the traditional, you've got to give people 3 days to take a look at these things and walk away, and that's 3 business days. The other document that Ryan has is a frequently asked questions document. And this is something that if I were representing a seller, I would pass on to the condominium of the co-op association management company. And I would do that when you have the listing so that it's prepared well in advance, and you're getting this from somebody other than the seller that has an obligation to be accurate and definitive. Not required at all. So, this is just something that helps the seller, just like any other seller disclosure, to the extent they provide this information. The buyer can't ever say that you didn't tell them something that was a material fact. I think that's the general gist of it. If other people if anybody has questions, happy to answer it. They're mostly.
I know I have one or two, and then if anybody else wants to pop out, they can. In selling or buying a co-op, are the reserves the most important factor to offset chances for future assessments?
Sure. That's a big one. It's really no different than a condominium association to the extent that you own a percentage of the common areas and you're responsible to pay in the same. Then you want to have the same level of scrutiny over the finances, see if there are any reserves, see what projects have been done, see what the finances look like for the last year. So I don't see a huge difference. I will say that the definition of pending special assessments is better defined in the condominium rider than in the co-op rider. This just says pending and doesn't give that definition of has it been mentioned for the last 12 months in the minutes of the meeting or the agenda item.
Makes sense. Is there any kind of a seller's disclosure that's required with a contract for a co-op?
Yeah, so no is the right answer, just like there is no seller's disclosure that's required in a condominium or anything else. There is the question and answer sheet that you provided, but there's no seller's disclosure like, have you ever had a plumbing leak, or do you know of any environmental hazards, or is the electrical up to code? Nothing of that
And
sort.
that FAQ is also not required, right? It's just like, this is a good idea to get, or it is.
No, it is. It's the question and answer sheet. And as you can see in paragraph 9, it is required to be delivered and give them 3 business days to review it, after which they lose their right to terminate.
Got you. Are there association dues in addition to the monthly lease payments? So are there multiple sets of association dues or payments in a normal co-op?
So there can be, just like there can be in a condo association, you can have a situation where the original developer leased the property to the co-op, or the original developer kept the pool area and the cabanas for himself and leases those out to particular owners. So you really have to check it out. And this is one of those areas where I would encourage somebody to hire an attorney, whether it's me or anybody else, to take a look and make sure that your buyer knows exactly what they're getting.
Got you. What are some popular red flags or things that you suggest people look for in a co-op deal, or make sure that they pay attention to?
You want to look at the finances very seriously. You may want to suggest to the buyer to have their accountant take a look at the last year's expenses. You want to make sure that there is no mortgage on the property. That should show in the title insurance, and you should object to that very quickly. You want to make sure that there's no litigation outstanding with the building. You want to make sure that there's no land lease or recreational lease. Those kind of things are incredibly important.
In that example that you gave where it was started in the 60s, do you recommend people just avoiding those deals when they're towards the end of the time, or is there usually I mean, I know it's kind of a unique situation for all of our lifetimes, but is there usually a situation where, at the end of that 99 years, they're just going to do another 99 years, or is it something like we expect at the end of 99 years, everyone gets the boot?
Yeah, just for clarification, some of the nicest condos, perceived condos in Palm Beach, Breakers Row, are actually co-ops. And it's not a 99-year lease. It was a 75-year lease, and they're 30 years in.
Wow.
So, yeah, I mean, there's some people who 40 years from now are going to be giving back their $2.5 million co-op to the Breakers organization.
Wow.
And that's it. So they know they're buying it basically for 2 generations.
Wow.
And
that's unbelievable, isn't it?
And that's it. And that's a heck of an investment to make for 2 generations.
Yeah, absolutely.
Yeah.
Some think, can co-op purchase be financed? You talked about that a little bit, but lenders will finance, correct?
Yeah, I mean, look, number one, they're going to look to the borrower. I mean, you're signing that you're going to pay this money back no matter what. So the value of a co-op might be less clear than a condo, but they can get an appraisal on it, and you can finance it like any other secured asset.
Would you anticipate when those things get within that 30-year timeline that then they're not going to do 30-year loans, even though, ideally people would be paying off early, but they're not going to do a 30-year loan on something that expires in 28 years?
Right. And they're not going to lend full value either. I mean, they might lend 50% loan to value as opposed to 80%.
Yeah.
And they may have a 15-year payoff if it's a 30-year remaining term.
Are there any condos that are on leased land and run similar to like this, where it's a condo, but it's on some kind of a land lease?
There are a number of condos that have been subject to a land lease in downtown West Palm Beach, Waterview Towers. Sometimes people call it the Radiator Building. Not always the most pleasant thing to say about a building. But that's on leased land. That's actually leased from the city of West Palm Beach. Yeah.
Anybody else? Any questions? That's all the questions in the chat. Anybody else got anything? If so, speak up. Give it a minute to unmute yourself and get on, or type in the chat. Any more questions?
I had a question.
Sure, go ahead.
You did, I've never sold a co-op, and you did talk about the pool and everything being separate. Can you elaborate on that, what you were talking about earlier?
Sure. There are some, I don't want to say they're always New York developers, but they,
listen, don't be picking on the Northeast, Krasker.
Yeah, I'm from Boston, so those Yankees, they seem to have a greater level of complexity up there, and they seem to structure things more creatively than some people may expect down here. So those were the original ones. Is a couple of New York developers came down and did a 99-year land lease and built a co-op and priced it. And for the people who didn't understand what they were doing, they didn't care or recognize any difference. And the truth is, it was still an investment for 3 generations of families, and you were going to be able to sell much more quickly than would harm you in any way fiscally. But there are condos and there are co-ops down here that people have retained the recreational facilities. Look at Kings Point. Look at what's the other one out on Okeechobee and the Turnpike, Century Village.
Yeah.
They keep the recreational facilities, and you're required to pay a recreational fee, whether or not you go to the pool or not. So yeah, you have to be aware of that when you're factoring in what your monthly expenses are going to be.
Got it. Someone else came in and said, is there any way to tell that a place is on a land lease outside of that disclosure or those forms? Like, is there somewhere to look it up or check it out before you get?
Oh yeah, it'll be on title. It'll be an exception to title.
But in that case, you'd have to be under contract already to figure it out, really.
Correct. Now, I mean, if you're looking at buildings and it says cooperative, these are the kind of questions that you want to ask. If you're representing a seller, you want to speak to the management company and understand what these issues are well before you place it in MLS, and you want to put these in bold print, all caps, in your notes section.
Nothing on Papa or IMAP or anything like that to show that, or?
Recreational leases, no. If it was on a proprietary, a 99-year lease, yes, it would show leasehold interest. It would say in Papa.
Got it.
But again, you don't want to rely on Papa to make your determinations of what the law is, because Papa's wrong, just like everybody else in the world.
Yeah, it's all entered data. Okay, anybody else, any questions? Give you a minute here to unmute.
Question for you.
Sure.
Will it show up on previous titles issued? In other words, if you have a title policy, you can review it?
Sure. Sure.
Okay.
If you get the seller's title policy, and you could look at the prior deed in.
So there is a deed that would say co-op on it clearly that someone could see and
Yes,
check out. Okay.
it would be a proprietary lease, not a deed.
Got it. Anybody else, anything? Lots of questions this time. Good stuff. Last chance.
So Ryan, just a quick question. So you could not only be under contract, but you could actually have passed your inspection window. Let's say inspection window was 7 days, and then you wouldn't, obviously the title company probably wouldn't have the information that you need if you're a month away from closing, but you've already passed your inspection period. You're risking your client's deposit by not knowing that information in advance, correct?
I'm not sure I understand.
So he's saying if you went into a contract not knowing it was a co-op or not sure if it was a co-op or a land lease, and then you pass the inspection period and, a week before closing, now title says, hey, did you know this is a co-op? Does the buyer have the opportunity to then back out because they're past inspection period?
Yeah, so if there wasn't a co-op rider and they never provided any of the documents that are required under the contract, you still have 3 business days after receipt of those documents to terminate the contract and get your deposit back.
So just like condo docs, if you got them 5 days before closing and there was something wrong, you could walk at that time with no issue because you got them late. Whenever you receive them is when your timeline starts ticking on that, not when you're under contract or not inspection period.
Yep, absolutely.
Cool. Awesome. Anybody else?
Question.
Yep.
You talked about it not being a deed on public records. It would be called a proprietary lease. So the public records has the designation called proprietary lease?
Yeah, it'll say co-op,
Okay,
proprietary lease, whatever it's going to say. But it will be very clear that it's co-op and not a condominium.
I can share a little bit. I've got a co-op right now listed. It's only, I don't know, like 118,000. Had a good offer. Listing agent and myself checked because the person wanted to buy, giving a nice down payment, but getting a mortgage. Between the listing agent and myself, we easily reached out to 13 mortgage brokers. And you can get a mortgage, but only if it's like 150,000, 200,000 mortgage type. But for the little things, like 100, 120, whatever, if anybody finds a mortgage broker that will do it, nobody, not happening.
So
now, when
they
we sold
wouldn't-
it in New York and other areas,
So they
They
wouldn't
do.
lend on that amount, but what was the loan to value?
well, I'll tell you, loan to value.
Like, was it a 5% down conventional?
Yeah, no. That's what I
Was
was
it
trying to
50%?
think back to it. I know it was more than 20%. I don't know if it was 30 or 40, but still, they will not on the little ones. And again, if you find it, awesome. But we reached out easily, 13, including from our group, from our affiliates, and I couldn't find anybody. So if you do have one, let me know.
Got you. Someone else said, my client is under contract on a co-op in Lighthouse Point. Everything was going well until the HOA called my client for an interview day. The client is out of state in Ohio and cannot come to Florida. HOA and co-op is requiring interview in person. For that reason, they're going to end the deal, and the seller wants to keep the deposit. Can they keep the deposit?
Yeah. So it's interesting because many of these riders say that the buyer will cooperate to pursue the application. And there have been a couple of cases where the seller said, where the seller said, we're going to keep that deposit because we think you needed to travel and you knew that there was an obligation for an interview during the inspection period when you got the documents from us, and you didn't object during that time period. So we're going to hold your money. I just had another deal in Palm Beach with a 8-unit association, and they were doing the same thing. Nope, we want an in-person interview. And it turns out that the interviewing board member was 92 years old, and he didn't know how to use Skype or Zoom. And that was the only reason he was being insistent. So I set him up in my conference room and got him an Uber to drive him here, and got my client to be able to have a face-to-face quote meeting, but via Zoom in my conference room.
So that, though, as you know, is you guys just going above and beyond. But in that case where they refuse to do that and the buyer just can't come or refuses to come, do you think the seller keeps that deposit, or is it gray? Or
I think it's going to be a question for an appellate court, and a year and a half from now, you'll probably have a good answer to that question. But until there's an appellate court ruling, it's a gray area.
wow, that's a crazy amount of time too to keep a deposit, isn't it? Anybody else? Any questions? Last chance. All right, guys, Monday we are doing a marketing class with a new tool that we have with Trident Performance and Synergy that if you want to get access to, you have to be on the call Monday. It's totally free. So if you want to join that Monday at 11, next week we are doing the as-is contract. So we will see you soon. Paul, I know you're off for a bit. Enjoy your time. We'll see you next week.
Thank you. Bye.
Thanks, guys. Have a good one.
Thank you. Thank you.
Bye, guys.